So when we talk about civil liberties, this is what Wilson Chapter 5 is really dealing with. And it's important for us to understand the difference between civil liberties and civil rights, and oftentimes we get confused about the difference between the two. So civil liberties have to do with freedoms or rights that you have as a human being. Remember that the framers came out of the mindset of the Enlightenment that said that as human beings, you have certain rights that are natural to you. They named some of these in the Declaration of Independence, the rights to life, liberty, and the pursuit of happiness. But they know that that was not an exhaustive list. So they said each individual as a human being has these things that are natural to them. They exist regardless of any government. They exist prior to government. If you had a group of people and no government, people would naturally have these rights. The concern that they had and the experience that they had as they studied governments in the past and as they lived the life of a colonial people under the British system, they came to understand that the natural tendency of government is to try to put down rebellions, to try to stop criticism. That the natural tendency of government was to try to use its own powers in a way that will silence dissent. Because what governments actually want is they want a compliant population. That's the nature of government. Governments do not naturally exist and perpetuate themselves in order to maximize the freedom of their citizens. The natural tendency of government throughout human history, as they observed it, was to crush dissent. They don't want people criticizing the government. The government wants to be able to do what it wants to do, and it doesn't want people saying, don't do that. It doesn't want rebellions. It doesn't want people who speak their minds. And as they studied governments, this is the conclusion that they came to. So when they were drafting the Constitution, they included in the original draft of the Constitution, in that first draft in 1787, they included some specific protections for individuals, knowing that the government will tend to use its powers to tyrannize people, to dominate them. So they set up some specific protections that came out of their own colonial experience. In the process of ratifying the Constitution, as you read about in Chapter 2 of Wilson, is that there were people who were not satisfied with those protections. They said, you're creating a new central government that's much more powerful than the one we had under the Articles of Confederation. We know you think you're creating a government with limited powers, but in fact, we're not happy with how limited it is. We want even more specific provisions to protect us from the oppression of a government. Since this is the way governments act naturally, just because they're governments, and just because they have power, and they are occupied by people who want more power, the natural tendency is to try to limit criticism and to limit dissent. So we need some specific protections. So the idea of civil liberties is governments will naturally try to oppress us. They will naturally try to restrict how we live and what we do. In the area of natural rights, we really need to have a government that's limited in its capabilities for doing that oppression. It wasn't that they were trying to create a government that would never exercise like police powers, that would never restrict the freedom of anybody. So they're saying the natural bent of governments is to restrict people's freedom in order to accomplish what the government wants to accomplish. How can we protect ourselves against unreasonable exertion of government power against its own people? That's the idea of civil liberties. So you have natural rights, and we need protections against oppression from the government. This is different from civil rights. Civil rights cover two different kinds of things. One is civil rights are rights that are granted by the government. You receive this particular privilege, this ability, this capability from the government itself. Another kind of protection in terms of civil rights is the idea that the government is used as a tool for protecting the equal treatment of people in the country. So there are two kinds of ways that civil rights work themselves out. One is that the government grants certain rights, and part of its responsibility in granting certain rights is to make sure that those rights are distributed equitably, and the people can exercise those rights without undue restriction. And then the other is that when people have freedoms to do certain things, and those freedoms are protected by the government, that if somebody steps in and tries to restrict people's actions in those areas, that it's the responsibility of the government to eliminate that discrimination based upon some questionable characteristic. So we can think of lots of examples of this, right? So if we think about the concept of freedom of speech, you naturally, the framers understood, you naturally, as a human being, have the right to express yourself in the political realm. That has nothing to do with what government institution you exist under, what culture you're in. You have the right to freedom of expression, and the government will try to take that away if it's being too critical of the government. So you need to be protected by the government from the efforts of the government. But in terms of civil rights, we can think about, for example, the right to vote. People in the world were not naturally born with an inherent right to vote. That is, an inherent right to cast a voice, to make their voice heard in the selection of a political leader. That's not a natural right. And so in the political system where elections are central to the process, the government grants to certain people the right to vote. And if the government grants to certain people the right to vote, then it's the responsibility of the government to make sure that those people who have the right to vote are not unjustifiably discriminated against in trying to exercise their right to vote. Some discrimination's allowable, and some discrimination is not allowable. And so it's the responsibility of the government to make sure that people who have the right to vote are allowed to do that without unreasonable discrimination. Another example would be what kind of rights you have with regard to things that might happen in life. So for example, in terms of thinking about civil rights, you think about the freedom to eat wherever you want to eat. And there might be people who want to say, I don't want to serve those kinds of people. So there are some people that I do want to serve, other people I don't want to serve. And it's the responsibility of the government that says, if you have a facility, then there are reasonable and unreasonable forms of discrimination with regard to who has access to your facility. And so it's the government's responsibility to protect the free exercise of the right to eat in a particular restaurant, and to make that happen without unjustifiable discrimination. The right to eat at a restaurant is not a natural right. It's a right that you receive as a function of citizenship or a function of there being restaurants available. You don't have a natural right to eat in a restaurant. So the framers then say there are two kinds of things that they're concerned about. They're concerned about the government oppressing the people and protecting the people from the government, and they're concerned about other people oppressing people and the government stepping in to make sure that there's not unjustifiable discrimination going on. Now, there's justifiable discrimination all over the place that the government has nothing to do with, or the government sometimes puts into law. So, for example, when you think about a driver's license, right? A driver's license is a privilege that the government grants to certain people. And it has the right to restrict who has the ability to achieve a driver's license. If you want to get a driver's license, you have to pass certain thresholds, right? You have to take a test. You have to be a certain age. You have to prove that you have insurance. And if you meet those three tests, and you can see, right, then you can receive a driver's license. This is a privilege granted by the government. But if you fail the test, if you don't have insurance, if you can't see, and what's the third one I said? And if you're not over a certain age, if you're below a certain age, then the government has the right to discriminate against you. So you are not born naturally, inherently with the right to drive as a human being. The government grants the right to drive to certain people, and then has a responsibility to make sure that that right does not involve unreasonable discrimination. Not no discrimination, but unreasonable discrimination. Sorry. So what we're going to talk about today are a handful of civil liberties. And then we'll talk on Thursday about a handful of civil rights. There's a really long history in this. There's a long set of topics that we could cover. In fact, we have an entire course that's just about civil rights and civil liberties. And you can go to some places, they have an entire course just on civil liberties and a whole separate course just on civil rights. So what I'm trying to do is give you, based upon the reading that you have in chapters 5 and 6, kind of a handful of topics that I think are interesting or currently relevant or that I think are critical for us to understand. Questions about those differences before we go on? Now, when we think about civil liberties, again, we want to think about the kinds of things that you have as a human being that accrue to you because you're a human being. And then we want to think about, all right, well, why would the government be challenged by that? Why would the government have an interest in trying to limit your exercise or your action in that particular area? So one area, and I'm basically going to take these in an order that we'll talk about a little bit in class, but was important to the framers. One was freedom of religion. Now, it might seem like freedom of religion, your ability to believe whatever you want to believe about a God or not believe about a God or whatever, it seems like an odd thing. But in fact, when you think about the role of religion in people's lives, what religion does is it says, for example, somebody raised the idea of deifying the leader. Did you raise that? The idea that in North Korea, for example, that Kim Jong-un is essentially considered to be a kind of God. He's worshipped in a certain way. Why would a government need to do that and then restrict all the other religions? Because the nature of religion is to set up an authority separate from the civil government. Remember, this is one of the key pieces of the Declaration of Independence. So there's a law that's the government of Britain, there's the king, and then there are these separate laws that are apart from the government of Britain and above the king, the law of God and the law of nature. Right? So the idea that religion comes into play is the idea that there is an authority that is higher than the government. Well, the government doesn't like that. Governments are not comfortable with there being an authority greater than the government. Because if there's an authority that's greater than the government, and the government tells me to disobey the religious authority, then I'm faced with a conflict in terms of who's in charge. So there's a famous family in the Netherlands during World War II, and when the Germans occupied the Netherlands, this family was a set of Christians, and they were protecting Jews because it was illegal to protect Jews. And so this family took a bunch of Jews into their home, and then when the Nazis found out, when the Gestapo found out, they came and they arrested the family. And they found out they were a Christian family, and the officer that was there in charge of the Gestapo raid on the house said, "What does it say in that book of yours," in terms of the Bible, talking about the Bible, "what does it say in that book of yours about obeying the government? Aren't you supposed to obey the government because that's what we say? We're the government, therefore you should obey us." And the father responded, "We're supposed to obey God, not the government." Religion places an authority that challenges the legitimacy of a civil government. And so governments all over the world seek to control religion. If you go to China today, the Chinese government seeks to limit religion. It outlaws some religious sects. It oppresses other religious sects. And if you don't comply with the laws in China, so in China, in order to start a church, for example, you have to guarantee that that church is going to incorporate Chinese socialist teachings into the theology of the religion in order to get a license to operate the church. Why does the Chinese government do that? Because they don't want some religion coming along saying there's a law higher than the Chinese government. Governments don't like the competition. Virtually every government in the world has a church that is the officially state-sanctioned government. I mean, the state-sanctioned church. So there's the Church of Canada. There's the Church of England. There's the Church of Germany. There's a Church of Sweden. These are the official state-sanctioned church in those countries. And part of the reason that states partner with churches, there's even the state church of Russia is the Russian Orthodox Church. The reason they partner with those churches is because it lends them a religious authority to their laws. The government does not like religious competition for authority, so it tries to leverage its position. The United States has no official church. There's no Church of the United States. It doesn't exist. That was intentional. You naturally, as a human being, one of your natural rights is freedom of speech, the right to express yourself. Government wants to limit people's freedom of speech, especially when it is critical of the government itself. Because the government wants compliance and it wants obedience. It does not want criticism. A free press is critical. It's a natural way of the masses to engage in mass communication, not just individuals one-on-one, but have organizations that combine their resources to investigate the government. Governments don't like that. They don't like organizations that are going to come around and investigate them to try to find out what they've done wrong. When you look at oppressive governments all over the world throughout history, challenging religion, shutting down political expression of the masses, and controlling the media are all tools that governments try to use to limit those rights of the people under their jurisdiction. You have natural freedom to gather. The government doesn't really like that, because what it means is that you have the ability to protest in mass demonstrations what the government is doing. The government doesn't want that. The government wants compliance and peace. They want domestic tranquility, right? Which is nice. What that means sometimes is they want to limit protests against what they're doing. You have the freedom to petition your political leaders. That's a natural right that you have. The government doesn't really want that because it doesn't want the people complaining about the government. The government doesn't want people making more and more demands as a general rule. And then finally, you have the natural right to personal self-defense with actual weapons. Governments don't want that as a natural consequence of their wanting to make sure you're in compliance with them. They don't want you to be able to defend themselves if they become tyrannical. Now, if you put yourselves in the minds of the framers in 1776, 1777, 1787, 1790, they're thinking, all right, what are the actual abuses that we have faced as colonists? Which of those abuses are abuses of our natural rights? How has the government sought to impose its will on us unjustifiably? And so they sought to incorporate these tools into the Constitution, both in the text and in the first 10 amendments, to protect the people from the government. Thoughts about that? So natural questions that comes up, and your textbook talks about this, but it's kind of a nuanced idea, so I think it's important for us to talk about. The question when we're talking about limiting the power of government, limiting the ability of the government to restrict you, or taking the powers of the government and constraining them, or requiring them to intervene. The question is, which government are you talking about? The original Constitution, the original amendments, as you read through the first 10 amendments of the Constitution, many of them start off or have somewhere in its text, Congress shall not. So the idea under the original Constitution was that you have a federal system. You have the national government and you have the state governments, and the real danger was from the national government. So they set up specific restrictions against the national government. The restrictions were not against the state governments. So the limitations that we see in the power of government in terms of restricting their ability to restrict religion or press or speech, those restrictions did not apply to the state governments. They applied to the national government only. It wasn't until the 14th Amendment, after the Civil War, that it became explicit that these restrictions on government power came to be applied to the states. And the 14th Amendment has two clauses that are relevant here. The first one is the Due Process Clause. It says that no state shall make or enforce any law, nor shall any state deprive any person of life, liberty, or property without due process of law. So this is what guarantees you, as a resident of Michigan, that Michigan will not deprive you of life, liberty, and property, and will guarantee you a just criminal justice system apart from whatever Congress does. So the states are required to have just systems in place, just protections in place for the people. The other piece of the 14th Amendment is the Equal Protection Clause. The Equal Protection Clause says that the states will not deny to any person equal protection of the laws. So whatever laws that are out there have to be equally applied to all members of society, not just of the groups that any particular government might like. So the Due Process Clause and the Equal Protection Clause are both ways of taking the Constitution's limitations and applying them to the state governments, as well as requiring states to step in to ensure that people are treated equally within the states. So as we think about civil rights and like the right to vote and the right to an education, those are rights that are granted by the government and has an interest in making sure that there's not unjust discrimination in exercising the right to vote and getting an education. And under the Equal Protection Clause, those laws that were granted by the government were not being equally distributed in the government. And so the civil rights movement was in large part about applying this particular clause to the states, because the southern states were being notoriously horrible about making sure that everybody who constitutionally had the right to vote actually could vote. That constitutionally had a right to education were getting an education. Now, the process by which this happened, even though the 14th Amendment was passed right after the Civil War, it took a long time for these rights to actually be applied to the states. And the process by which this occurred was called Selective Incorporation. Even though on paper the 14th Amendment says, all right, everything applies to the states too, in every case, a particular right or a particular liberty had to be contested in the courts. And so on a case-by-case, situation-by-situation basis, these rights came to be applied to the states. And these limitations came to be applied to the states. So even though on paper, in one of the Civil War amendments, people of color were given the right to vote, you were not denied the right to vote on the basis of color, in fact, the state laws did that for a long time. They did it for another 100 years, until eventually the federal courts stepped in and said, under the Equal Protection Clause, you are not taking this particular right that is granted to some people, and you're not ensuring that it is being equally provided to everybody, and you're denying some people on the basis of their color. And that violates this provision of the Constitution. And that didn't happen until the 1950s. So this process took a long time on a case-by-case individual situation basis. Second major question is not just which government is involved here, But what does it mean to be a person? The definition in U.S. law of a person is a human being, so you're a person. But an additional definition of a person is any organization or business that you start. So let's say you start a nonprofit to feed the homeless. Or let's say you start a business in which you want to be a baker or be a photographer. Your business or the organization that you set up, even if it's for a profit, is considered for legal purposes to be a person. So you're protected. For example, the government cannot just come into your house and search your house without reasonable cause, right? You need a search warrant in order to do that, right? If you own a business, the same protection occurs to your business. So if you own a business, the government cannot just come in and search your business because it's a business. No, for the purposes of the law, your business is the essential equivalent of your person, of who you are. So the protection that you have against government interference also applies to the business that you own. If you have freedom of speech, the nonprofit organization that you start also has freedom of speech. This is a really important principle because sometimes we think, well, that's a business, it doesn't count. But in fact, under US law, this application of laws considering businesses and organizations to be a person for legal purposes is critical to the exercise of our rights. Because if I, as an individual, if I have the right to free speech, that's nice. But if I start a business for myself and I go out and I start talking about things in which I'm critical of the government, and that company that I start for myself does not have the same right to free speech that I have, then the government can shut down my business because I'm exercising free speech, and that's not a person. So from a legal standpoint, the codes that are in the government's law, apply the same principles for personal behavior and personal protections to the businesses you start. This most recently and prominently came up in the Hobby Lobby case from a few years ago. In the Hobby Lobby case, this was where, under the Affordable Care Act, there was a requirement that businesses that provide insurance to their employees are required to provide access to birth control and access to abortifacients, that is, drugs that will induce an abortion. So there were a few companies that are owned by Christians, run by Christians, and they said, you know what, we don't think that it's right that the government is requiring us to make sure that our employees get their abortion-inducing drugs paid for by our insurance company. And so there are a number of companies, but the one that's most prominent is Hobby Lobby. And so Hobby Lobby sued the federal government and said, this is our company. You cannot force us to do this thing that violates our freedom of religion. Our religious expression is we do not want to provide access to our free access for our employees to abortion-inducing drugs. If they want to have an abortion-inducing drug, they can do that, but you can't require our insurance program to pay for that. So the question then emerged was, well, is Hobby Lobby a person that has the ability to exercise this freedom of religion in this way? Or is it a company that's required to treat all of its employees with a certain standard that might be different from the preferences of the owners? The Supreme Court decided that Hobby Lobby was right, along with other companies that it signed on with that. And in the Hobby Lobby decision, there's this passage that says, an established body of law specifies the rights and obligations of the people, I italicize the word people in that, including shareholders, officers, and employees who are associated with a corporation in one way or another. When rights are extended to corporations, the purpose is to protect the rights of the people. Protecting the free exercise rights of corporations like Hobby Lobby protects the religious liberties of the humans who own and control these companies. The argument is, this family owns this company. They run it. You go to Hobby Lobby up on West Main, You listen to the music, and if you are a Christian, you recognize all the songs they're playing because it's Christian music. They run the company as a Christian company. And so the company then acquires, by law, the religious freedom that its owners, the Green family, that family has. Now, this decision was applied to a relatively narrow kind of company. It's basically applied only to companies that are held by a small number of people. They're privately owned. This does not apply to a mega corporation like Microsoft. Microsoft is kind of run by Bill Gates, but it's not really a product of Bill Gates' values, but Hobby Lobby is. So they separate out different kinds of companies. So their ruling here was that for some companies that are owned by a small number of people, and that company is run according to the values of those people's faith, then the protection that they have for the religious exercise applies to the company as well as the owners. But not for a big publicly held corporation like American Airlines or Microsoft or IBM, not those kinds of companies, just the kind of companies that are held by a small number of people. So this was the decision that they made in terms of helping us to see really explicitly that corporations and businesses set up by individuals are given the same civil liberties protections as the individuals who set them up. And you can put yourself in their spot. If you start a business, or if you start a nonprofit, the rights and protections that you have also apply to your company. When you sell it, or you go public, it's a different thing. But while you're still owning it and running it, that's your thing, and that has the same rights and protections that you have. Do you have questions about that?